Justice Thomas?
Ms. Hope, would a victory by the third person who was never convicted under this ordinance in a 1983 action, would it impugn the reasoning underlying the conviction of petitioner?
Yes, absolutely, Your Honor. And
would
that's,
it impugn it any differently than if petitioner brought the 1983 action?
no, Your Honor.
Would it undo the conviction or the confinement of petitioner?
No.
Justice Alito?
If I think that your blanket argument that heck doesn't apply to prospective relief under any circumstances goes too far, what would you propose as a backup argument that would result in a decision in your favor?
So
Do you have a more qualified argument?
Sure. I think we could rely on Heck itself and say that prospective relief, where no element of the Section 1983 claim, no element of the federal 1983 claim requires the petitioner to prove the invalidity of the prior conviction. No element of the claim would do that. I think that would be another way, Your Honor, consistent with Heck, to further limit prospective relief.
I'm not sure I understand that. If the plaintiff in the 1983 case has been convicted of violating a statute, and the statute is declared in the 1983 case to be unconstitutional, why doesn't that undermine the...
I understand Your Honor's question. I was taking it more as just a general rule, regardless of the circumstances. I think perhaps one line, and my friend can perhaps say more about this theory. I think the Solicitor General's office has suggested one line you might draw would be in terms of custody. That if, as Mr. Olivier, if the former criminal defendant is not in custody, there would be no barrier. If the defendant were in custody, then that would be a different rule. So I think that would be another line that this court could draw.